Hello, I'm Hannah Craven, a solicitor here at Winston Solicitors in the family team. Often when spouses are going through a separation or indeed have separated, one obvious important topic is the arrangements for the children. Where they should live, who they should live with, how much time they should spend with the other non-resident parent. And what does that look like? What is the answer? How should that be arranged? In short, there is no right or wrong. The arrangements need to be agreed by those who have parental responsibility for a child or children. And it's always important to remember that it's the child's right to spend time with their parents, not the other way around. When we talk about parental responsibility, what we are referring to is all the rights, powers, duties that parents have in law for their child. Mothers have automatic parental responsibility for their child. In terms of fathers, if they are married to the mother at the time of birth, then this will confer upon them parental responsibility. If they are not married, then if they are named on the child's birth certificate as being the legal father, then they will also have parental responsibility for the child. There are circumstances in which an unmarried father may not have parental responsibility, and there are a number of options that they can consider in order to obtain that, whether that be via an agreement or an order of the court. Ultimately, we are looking at the important decisions about a child's upbringing, such as their name, where they go to school, medical treatment, and all those really important aspects of a child's upbringing. Now, as I say, all those important decisions need to be agreed by everybody who has parental responsibility. And a really good way to evidence and document agreement is to have a document known as a parenting plan prepared, which sets out the care of the children. If it is not possible to come to an agreement about the arrangements for a child or other important decisions about their upbringing, then a court application may be required. And ultimately, if asked to, the court will make a final decision about those particular aspects. Of course, applying to court is always a last resort due to the time and expense involved, and other forms of non-court dispute resolution should always be explored in the first instance. The court are very reluctant to intervene in family life and make decisions about children that they do not know and have never met. The law does require you to first attend mediation before you are able to make an application to the court. And if a court application is required, then you would be likely applying for what is known as a child arrangements order, which effectively deals with the living arrangements of a child, such as who they live with, how much time they spend with the other parent, etc. There are other court orders that you can apply for in the event of a disagreement about certain aspects of a child's upbringing, such as change of school, change of name. And in those circumstances, you are asking the court to make a decision about a specific issue. That is called a specific issue order. Now, if a court application is required, then CAFCAS will become involved. CAFCAS are an advisory service designed to look after the interests of children in court proceedings. CAFCAS provide the court with advice about what they consider to be in the best interests of a child. Because ultimately, at the heart of these proceedings, the child's welfare is the court's paramount consideration. And provided that the child spending time with their parents does not lead them to any harm, then the court will generally recognise this as a positive thing and encourage contact to take place where possible. There is also a presumption that the involvement of both parents in a child's life furthers their welfare, and often clients of mine think that the court favour mothers or maybe favour fathers. This is not the case. There is absolutely no discrimination between both parents, and the involvement of both parents, provided it is safe, is well recognised as being a positive in a child's life. In West Yorkshire, there is a pilot scheme in place which has been designed to speed up applications to court concerning the arrangements for children. If you have any queries about the arrangements for your child or children, please do not hesitate to contact the family team at Winston Solicitors on 0113 320 5000.